Good afternoon. My name is Dave Zapponi. I'm the Executive Director of ECHO, otherwise known as the Educational Council of Homeowners. We are based in San Jose with satellite offices in Tracy and Laguna Hills, California. Thank you for participating in the ECHO live stream event on opening HOA communities after COVID, featuring John Gill and Rolf Crocker. ECHO is a statewide nonprofit association created to support HOA members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connection. ECHO is 47 years old, which makes it the oldest association representing the collective interests of HOAs in the state of California. It prides itself on providing quality education programs based on building stronger communities. Before we move forward with the program, please note, the webinar is scheduled for 1 hour and a half. Please feel free to leave the meeting at any time. We will mute attendees during the presentation to help with sound quality and to assist the speaker in developing concepts. Please note that we use the chat feature for technical issues and the Q&A feature for content-related questions. You may ask questions throughout the presentation using the Q&A feature. Please be courteous and respectful of the meeting participants at all times. We reserve the right to mute or remove participants at any time and for any reason during the meeting. This program is copyrighted by ECHO and will be recorded. We do not give permission to others to record the meeting without prior authorization. A copy of the recording along with the presentation slides will be emailed to registered participants within 7 to 10 days. ECHO is a nonprofit corporation which has and strictly follows an antitrust policy. It is available for review on our website at www.echo-ca.org. Finally, none of what is said during the meeting shall be construed as specific legal advice from either the speaker or ECHO. If you wish specific advice, we encourage you to ask your attorney or contact John Gill after the meeting. We want to give a special thanks to our sponsors. The question and answer session is underwritten by Hughes, Gill, Cochrane, Tinetti, PC. Our live stream program sponsor is OMNI Community Management, LLC. We will now hear a few words from our program sponsor. Rolf?
Well, good afternoon, everybody. My name is Rolf Crocker. I'm with OMNI Community Management. Honored to be with you today. OMNI was founded in 1996. We're a mid-sized, locally owned management company. With a focus on education, we believe in the value of what we call T3, trust, team, and transparency. Trust is very fragile, but it's critical for everything that we do. Team involves everybody knowing what their roles are and working together for a positive outcome. And finally, transparency, not just transparency in terms of what we're doing on your behalf, but also transparency from us that if we make a mistake that we self-disclose that. So, you know, we don't say that we're perfect, nobody is, but we work very diligently to cultivate a trust relationship with all of our clients. So if any of this is something that would be helpful to you, feel free to reach out and we'd love to chat with you. Dave?
Thank you, Omni. At this time, I'll introduce our speakers for today's presentation on opening HOA communities after COVID. John Gill is a principal and founding shareholder of Hughes, Gill, Cochrane, Tinetti, PC. John is a construction defect specialist with deep HOA general representation roots. John also serves on the ECHO Board of Directors. Rolf Crocker is the principal and chief executive officer of OMNI Community Management with offices in Fair Oaks, Walnut Creek, and Reno, Nevada. Rolf also serves on the ECHO Board of Directors. Rolf?
Indeed. Well, that's the turnover, right, Dave?
That's it.
Yeah, excellent. Well, again, good afternoon, everybody. Appreciate you spending some time with us this afternoon. This topic has probably been the #1 topic that we've been hearing about, both in terms of the ECHO board and certainly among our clients at OMNI. Again, we're all finding different ways to weather the storm, but now that the things are starting to loosen up a little bit, what does it mean as a practical matter for us? So what we're going to cover today in the agenda that you see in front of you is we want to talk a little bit about where we've been and then where we are today. John's going to talk about the board's fiduciary duty. We would love to give specific advice to every one of you in terms of your specific situation. But what we're really looking to do overall, the only thing we can practically do is to equip you with information that can help you assess the risk as it is relevant to your association. So John's going to speak to that. We'll talk about the board's authority, responsibility, and liability. Big question, reopening amenities, especially the pools, right? I think, if you were to raise your hand and say, yeah, that's me, I think most of us would like to know about that. But it's also tot lots, sport courts, clubhouses, things like that. We'll talk about reopening meetings. What does that look like while shelter in place is still going on and as it lifts? Budget and collections, how does that work under this pandemic? And then finally, what do we do if shelter in place is reinstituted? And then we'll have a time for question and answers at the end. So with that, we'll go to the next slide. And John, feel free to.
Thanks, Rolf. As we begin, it's important to state my practice is primarily in the Bay Area in Northern California, but primarily the Bay Area counties. So I am most familiar with the orders that have been issued by the Bay Area counties. Rolf is in both the Bay Area and the Sacramento and Central Valley, a little greater breadth to his knowledge base perhaps. But again, what we're talking about to you today are general considerations that everybody will want to take into account in making decisions for the betterment of your communities. Some of the specifics may come out better in the question and answer at the end of the program, and we are going to leave at least 30 minutes for question and answer, but the questions and answers will have better context based on the general information we're going to give you in the next little bit. So we're starting with where we've been and where we are now in the context of the COVID-19 situation that we find ourselves in. We are here on June 4. It was 3 short months ago that are probably the longest year any of us have lived through, that that Governor Gavin Newsom issued a declaration of a state of emergency for the state of California. That wasn't the first shutdown order, shelter-in-place order. That was simply declaring a state of emergency, which has an effect on the provision and availability of government services and funding. The state of California, if I recall correctly, wasn't the first to issue a shelter-in-place or stay-home order. The first that we became aware of were actually the 6 Bay Area counties that were working in tandem at the time. On March 16, the 6 Bay Area counties and Berkeley issued shelter-in-place orders that were subsequently expanded throughout the state. The state of California first issued a shelter-in-place stay-home order on March 19, 3 days after the Bay Area counties did. And the shelter-in-place orders initially, and in large measure still, cover a variety of things, such as leaving home for essential purposes only. Essential purposes don't include travel, largely recreation or things of that nature. It's being able to shop for essentials, for medical supplies, attend medical appointments, food and other necessities, healthcare, things of that nature. Work outside of the home was limited largely to essential businesses, including obviously medical providers and first responders, but also essential businesses as have been defined in those orders, and have gotten even more strict over time with essential tasks necessary for businesses that can't be performed remotely. And at least in the Bay Area counties, that is, and I think throughout the state, that is still largely the case. The fact that businesses in some cases, other than retail and restaurants and others, may be allowed to stay open doesn't mean everybody gets to go back to normal. For the most part, we're all required to work remotely to the extent that we can to keep the business running. The counties, particularly in the Bay Area, generally were in lockstep in terms of approach from the beginning. The shelter-in-place orders also have prohibited all public gatherings, have required social distancing. At first they didn't, but a short time later required the wearing of masks in public places. and in some cases even outdoors if you're within 6 to 30 feet of other people. And the closing of the shutting down of public amenities has also included the closing, for the most part, of all commonly used recreation facilities, both public and private. And that has had a profound impact on homeowners associations and the common amenities that are used by all association members and residents of the communities. At the time, the governor initially, through the California Department of Public Health, issued or defined a 4-stage reopening process. Rolf is going to talk about that in a minute. So that brings us to where we are right now. We're right now at a stage 2 limited reopening under the state's Department of Public Health guidelines. And again, Rolf will get to. But we're also finding that the counties are operating more independently based on local needs, local conditions, and in some cases, local interpretation of what the state can and can't regulate. And we're going to talk about that a little bit, particularly with regard to pools in a little bit. And what we're finding, everybody wants to be safe, but there is also a large segment, and many of us may be included, that are also feeling done with all of this, which, regardless of how we feel personally, really can't have an effect on how board members make decisions for the betterment of their communities. So, Rolf, why don't you talk about the 4 stages of reopening?
Sure. So just so we're clear, we still are under a statewide shelter-in-place order. That order has not been lifted in its entirety at all. We're currently in what is known as stage 2, which is lower risk workplaces with significant modifications, protocols, and requirements to do that. There are 2 levels of stage 2. There's what they call the sort of initial stages, and there's what they call enhanced stages. Enhanced stages include such things as possibility of dine-in restaurants, haircuts, things of that nature. But in order to reach a stage 2 enhanced, you have to certify with the state of California that you meet the qualifications. As of this morning on the San Francisco Chronicle website, something we've been scouring among other publications every day since this has started, there are currently 7 counties in the state of California that have not achieved stage 2. And those are the 6 Bay Area counties plus Imperial County, which is in essentially the lower east hand of the state. All the other counties have applied and have received permission from the state or certified that they can do enhanced stage 2. But right now, the Bay Area continues to be under the lower risk stage 2 requirements, which still has significant restrictions as a part of it. Without getting too far afield in the presentation, obviously this is going to relate to a lot of the stuff that we're talking about today. So if you're joining us today from other parts of the state, we know that we'll try to make this as general as we can, but a lot of the people that we have on today are from the Bay Area, so this will be for necessity directed at a lot of that, and there are still significant limitations in the more restricted stage 2.
So let's talk about fiduciary duty, and just sort of for context here, every individual may have different feelings about what is and isn't necessary, whether the county health departments in the state are acting appropriately or not appropriately, whether we think this is right or wrong, too strict or not strict enough. There are as many opinions on those subjects as there are people holding those opinions, which should have nothing to do with how boards of directors make decisions. How we feel personally about things is entirely related to how, as board members, decisions are made for the benefit of the entire community and the entire association, which brings us back to fiduciary duty. And without question, this pandemic has caused unprecedented challenges for boards, managers and management companies, and association members generally, all of whom have their own separate opinions as well, regardless of what the board does. So how do board members deal with all this? Well, all board decisions and actions have to be evaluated through the prism of the board's fiduciary duty. And the board has a fiduciary duty to all members and the entire community. Fiduciary duty is the legal foundation of everything the board of directors does in decision making. So we start with, what is a fiduciary? A fiduciary is a person to whom property or power is entrusted for the benefit of another. If I live on a 2-acre parcel and I'm not part of a homeowners association, I can't break the law, but I can make decisions about what happens on my property otherwise. It doesn't affect anyone else. I can do essentially whatever I want. In a homeowners association, if I'm a board member and a fiduciary, my decisions have to be for the benefit of all, because everyone is entrusting their money and property to me to make the right decisions for the right reasons. So fiduciary duty is actually codified in what's called the business judgment rule in the Corporations Code, section 7231. And what it essentially says is that board members must act in good faith. Everybody knows what good faith, it's for the right reasons. And those right reasons have to be in the best interest of the association. It's not what makes everyone happy. And the board in this context can be forced to make decisions that are going to make people extremely unhappy. Happiness isn't the test of whether the board has fulfilled its fiduciary duty. In the best interest of the association is what's best for everyone in the board's decision, only after reasonable inquiry. Reasonable inquiry is probably the most important and often misunderstood part of fiduciary duty. Reasonable inquiry means the board has a duty to investigate and obtain reliable information to make informed decisions in everyone's best interest. Where board members get caught up with reasonable inquiry is where it costs money to get reliable information, whether it's legal advice, whether it's talking to professionals in a given field about physical conditions in the property, whether it's getting tax advice through a CPA. In this context, reasonable inquiry in complying with the law suggests that all board members should be talking to the association's legal counsel about what the board can and can't decide, and about what the board should and shouldn't decide, and how those decisions should be made. The information that Rolf and I are providing you here today, and I'm a licensed attorney that represents homeowners associations, this is useful to you for context, but for purposes of fiduciary duty, I would caution all board members in attendance that you should take this information to guide you in seeking the right type of advice that is relevant to your specific communities. And again, reasonable inquiry gives the board useful information that the board members can rely on in making informed decisions. And then again, the board members must act in a way that an ordinarily prudent person would act under similar circumstances. So a couple of examples of how this might play out. If everyone in your community is outraged about the county health department shutting down amenities and demands that the board ignore them, should the board ignore the law? Well, reasonable inquiry suggests, and acting prudently in everyone's best interest suggests and demands that board members follow the law to the greatest extent possible and seek legal advice on how to do so. The other question we get asked frequently is, well, when it comes to reopening amenities, and we'll talk about this in a few minutes with regard to specific amenities, why can't we put this out to a vote of the membership when we're taking all these considerations into account and ask the members to vote on whether we open and whether we close? Well, there is a difference between opinion and duty, everyone's individual opinion, and the board member's fiduciary duty. And you don't want to confuse your duty with everyone's opinions. So the board members have an obligation to make all of the decisions on behalf of the association that aren't otherwise specifically delegated to members. And how the common area is maintained and kept in good repair and operated, these are board decisions that the board cannot abdicate to the membership with a vote. Even if the membership vote is overwhelmingly to take a certain action, that doesn't prevent the board members from being potentially at legal risk for violation of their fiduciary duty for not making the decisions in the right way. So again, everyone has an opinion. the board members have a duty, and the fiduciary duty is significant to how you go about making your decisions in everybody's best interest. So, Rolf, you want to follow up with this regarding the board's authority? And
let's go back for a second, Hannah, because I want to, you know, I'm not an attorney and I don't play one on TV, so I want to make sure I'm giving you that qualification. You know, again, here to John's point, just to enhance it a little bit for you, is that, you know, I often say that decisions have two components. There's a political component and an economic component. And the political component is not unimportant, especially in the HOA world. So much of what we do, and certainly what you do as board members, involves having to govern your peers and your neighbors. And you're trying to do the right thing on behalf of others and not get caught up or wrapped around the axle on either side of an opinion, whatever that opinion may be. So to recognize that that is a challenge, I at least want to put that out on the table, that that's absolutely a challenge. But to John's point, you know, we talk about board of directors. I like the word trustee, because trustee is responsible for that which is owned by others. You're always going to have a reaction as a homeowner, and there's no shame in that. The challenge is you have to take off your homeowner hat, put on your board hat, and say what is in the best interest of the association. And the thing we try to focus on for management with our boards is we're trying to alleviate the association from legal or financial liability. So the decisions, the things we're talking about in terms of a practical way, just want to kind of break that down to a practical way in the boardroom every day when you're walking around with your neighbors. There is a duty, but it also affects you where you live. And as I often tell my own staff, we don't live there, the board members do and the members do. So to recognize that and to realize that on a practical matter, I think is important. So,
and it's also significant to board members with regard to, you know, there's the liability of the association if something goes wrong. Then there's the liability of the board members for whatever goes wrong if the board doesn't fulfill its fiduciary duty. So the whole concept of the business judgment rule and fiduciary duty is that if board members make decisions for the association for the right reasons, in the right way, with the right motivations, relying on advice, the association may still be liable if something goes wrong, but board members are protected from personal liability and will be protected by D&O insurance if there's a claim made, if the board members complied with the business judgment rule. So what the law recognizes is that when board members make decisions in the right way for the right reasons to protect themselves, you should act out of self-interest from a liability protection standpoint, because the law says that's what's best for your communities. So this isn't substituting your judgment for everyone else. It's making decisions that you're entrusted to make in the right way. And you really need to look at all of these things in that context.
Absolutely, and this frames up everything we're going to be talking about throughout the rest of the program. So thanks for that, John. Hannah, if we can go to the next slide. So board's authority, responsibility, and liability. A lot to cover here. So first and foremost, following local and state mandates. That is so critical. There is disparity in these areas. I know that we're scouring information on all the counties' websites where we manage, trying to make sure that we have the latest information. Those things are updated, semi-regularly. And then number two, keep apprised of ongoing changes. You know, we were starting to move into stage 2, but then San Francisco decided to actually put an enhanced restriction with the wearing of masks in public places. So even while things are opening up, there can be circumstances that will actually bring you back to an enhanced situation in real time. So making sure that you're keeping apprised of those is so critical. Obviously, communication to the residents, and this is something we will talk about a lot as we go through the rest of the program. But making sure that you're in front in terms of letting your homeowners know what's going on, and most importantly, the why as to why you're doing it is so critical. Unfortunately, anything will grow in a vacuum, and if you don't set the narrative, other people will set the narrative for you. So it's so important that you set the narratives, and you do it from the place of duty, you do it from the place of the well-being of the association as a whole, and just keep people posted on changes. And sometimes even if there's not much change, sometimes just an email to follow up to say, hey, not much change, but just wanted to keep you informed that, you know, we know you're still there, and as soon as we hear something, we'll let you know. I know we've been sending out memos probably about every 3 to 4 weeks with our clients and with to our homeowners to keep them apprised of things. And again, there are lots of avenues to do that through email blasts, through postings at the clubhouse, if you have a website or a portal, those kinds of things. So just be aware that you're keeping things, the communication is important. And then on emergency rulemaking authority, John, I'm gonna let you jump in on the technical, and then I'll talk a little bit about the practical.
One last thing about communications with the residents. A couple aspects of this. How you communicate with your residents is an important subject. You know, everyone's familiar with social media, whether it's Facebook, a Google group, nextdoor.com, and social media has its advantages in terms of being able to communicate with people freely. It has its disadvantages with regard to a corporate homeowners association's communications with the members. You want to make sure that the way you communicate with the members is designed to reach everyone. And if you dive into the sticky wicket of social media on a Facebook page or on nextdoor.com, you're not necessarily reaching everyone, and you may find yourselves in a situation where people expect and demand immediate responses to their questions in an environment where everybody's scared. So I'm not saying you absolutely can't post association announcements on a social media platform, including nextdoor.com, but it certainly shouldn't be the only way you communicate. You want to make sure that your communications are limited to formal announcements rather than an informal give and take that could create its own liability risks. Emergency rulemaking authority. We have, are they reasonable? Are they enforceable? Well, there's another question, are they necessary? And let's take the example of pools that we're actually going to have a little bit more of a case study in a few minutes. We've gotten a lot of questions in advance of this webinar from attendees about what do we have to do to reopen the pool when the time comes, whether it's signage, safety measures, what have you. Well, the answer is we don't know yet. And you can take some comfort to an extent in the fact that each county is likely to give guidance on what needs to be done in order to be able to reopen your pool or any other amenity when the time comes. Now, possibly that won't be the case in certain circumstances, but we found, for example, ECHO put on a webinar a week ago on construction projects and reinstituting construction projects in HOA communities that I gave with Bill Mann. And when it came to allowing construction projects to resume in homeowners associations, the counties in the Bay Area at least are issuing a tremendous set of guidelines that have to be followed for health and safety protection in order to be able to proceed with construction projects. Now, I wouldn't assume that the extensive nature of those regulations will be the same, perhaps with other amenities, but I think it's safe to assume that we're likely to get significant guidance from the counties when those amenities can be reopened, and that's our starting point. So the next question has to do with rulemaking authority, and in particular, when we're dealing with a health crisis, should associations adopt rules in terms of how the common amenities, when they're reopened, should be used? Well, it depends, and there's a split of thought on that. Some lawyers are recommending the adoption of emergency rules that largely will relate to the enforcement of social distancing, 6 feet or more, the use of high-touch surfaces, what people need to do to protect themselves and protect others, all of which already exist in the county health officer directives. And so there's another school of thought that if you're not required to adopt additional or emergency rules, you might be better served in going the route of issuing warnings or disclaimers without adopting emergency rules. The downside of emergency rules relates to the financial and practical obligation of enforcement of them. At this moment in time, I and others in my firm are of the school of thought that when residents are upset that others aren't socially distancing or wearing masks in and around the community at this point. We believe associations reasonably can respond to such concerns by advising that they contact the police or the county health department. But there are many lawyers in the industry that are recommending that boards consider adopting emergency rules. And just for the authority to do that, Civil Code Section 4360D states that if the board determines that an immediate rule change is required to address an imminent threat to public health or safety, which would certainly apply here, or an imminent risk of substantial economic loss to the association, the board can make an emergency rule change and no notice is required, meaning you don't need to give 28 days notice to the members and consider comments before adopting it. The rule can be adopted immediately and published to the community. It's effective for 120 days unless the rule change itself provides for a shorter period of time, and it cannot be readopted as another emergency rule. The board would then have to go through the normal process of rule adoption. So, Rolf, what do you think are some of the political aspects of adopting such rules and enforcement?
Well, when we talk about, you know, the two rules of thumb for adopting rules, period, whether or not you're in an emergency situation or not, are the two that we have on the screen. Number one, are they reasonable? Are they rightly related to the association's obligation under the governing documents? Sometimes they are, sometimes they're not. And to introduce the elephant in the room, there's a certain television commercial that's been making the rounds the last couple of days from a certain well-known insurance carrier that talks about, that references life in HOAs. And with that being the reaction that some people get, I think to me, that's a way to reframe this question to ask, are the things we're doing really related to making sure that we're maintain, protect, and enhance the value of the asset, which are the property. And that's what the association exists to do. So they need to be rightly related to the issue. But are they enforceable becomes the more tricky part of this, because ultimately the association should have, per civil code, a violations policy. This should be getting issued out every year as part of your annual disclosure package that you're supposed to follow in terms of what people can expect when they violate one of the rules or the CCNRs. And there's a process that has to be followed that usually in typical times would be a courtesy notice, as sometimes is called, or an initial notice of the violation, a follow-up if it's not resolved, and then a hearing with the board in order to determine, to have a discussion to see if we can resolve this. The ultimate goal in that, of course, is you're trying to get compliance. It's not designed, or it shouldn't be designed to be necessarily punitive in nature, but it should be there to get people to comply and to go along realizing that when you move into a common interest development, you give up certain rights and you take on certain responsibilities in order to live together in common. But it's on the backside, the enforceability and the willingness of a board of directors to go to the mat, if you will, to enforce something. That's where these issues usually end up dropping. And there's also and again, not practicing legal advice, and John, feel free to kick me under the digital table if I'm stepping too far afield. But there's also something about taking on, as John had already referenced, enforcement authority when there already are governmental authorities who can handle that enforcement on your behalf. I'm always a fan of give the enforcement of those kinds of things that are under government and state mandates to those agencies in order to enforce, because ultimately homeowners associations have certain things that they can do, but we're ultimately not law enforcement agencies. We're just not. We can enforce things in terms of the care of the property, people's conduct toward each other within certain limitations, but ultimately we are not a law enforcement agency. And to the degree you can utilize that as your backstop, I think everybody's better off.
So to follow up on what Rolf just said, associations and board members aren't the police, and you don't want to be in the uncomfortable role of policing public health directives that are enforceable by the public health agencies and the local police if warranted, unless you're required to do so as a condition of reopening, as we have seen in some counties. I'll give an example a little bit with pools. So the association's responsibility and liability for acting or not acting, back to rules specifically, this is an area where you want to obtain your own legal advice from the association's legal counsel in terms of whether the adoption of emergency rules is appropriate, is necessary, and whether the association has the ability to fund the enforcement of it and carry through with the enforcement of it. There isn't a one-size-fits-all answer. So let's go to the next slide and talk about some considerations regarding the reopening of amenities generally, and then we're going to talk about some specific examples of amenities I think everybody wants to hear about. So we start with state authority. The governor and the California Department of Public Health have issued orders that obviously everybody has to comply with. The county health officer orders have been largely, but not entirely, but largely consistent with the state authority, and we'll talk about in some ways maybe they've deviated. The county health orders have been, for the most part, much more specific. These typically are the most relevant and specific. And again, I've had situations where board members have said, I know the pools are closed, it's absurd, we need to reopen, or the gym because people are getting stir crazy. You know, can't we just disregard that? What are they really going to do? Well, the penalties for the county health officer orders that I've seen include fines and imprisonment. And as board members, if your fiduciary duty is to protect everyone in the community, disregarding the orders of public health officials is not likely to be deemed in the best interest of the community. Knowingly violating the law, the same thing. And while I cannot tell you that every board member is subject to imprisonment and don't mean to do so, I can't tell you that you're insulated from that either if people out of convenience or for political expedience decide that we're going to disregard the law. We can't, not when you're acting as a fiduciary. So then rules and enforcement, we just talked about that a bit. Again, the association through the board has the authority to adopt rules related to the common area and the common amenities. Rules that you adopt, if you choose to adopt more specific rules, including emergency rules, need to be consistent with the county mandates and its possibility that the county mandates have all of the necessary protections that might make the adoption of additional temporary or emergency rules unnecessary. Again, that's something you should speak to the association's legal counsel about your specific situation. Again, we are advising our clients far more often than not that it might make sense to the extent possible to defer enforcement to the county rather than adopting specific rules that otherwise might be covered by the county health officer orders. We've been asked several times, well, when we reopen, can't we simply require everybody to sign a hold harmless agreement if they're going to use the pool or they're going to use the gym? Well, there are a lot of issues with hold harmless agreements. For example, you got to be 18 to sign one to be legally binding. There's always a question about whether people using the amenities truly understand the risks that they're supposedly waiving with a hold harmless agreement. The assessment of those risks largely and legally would be based on the steps the association claims to be taking for their protection and whether the association has carried out what it claims to be doing for everybody's protection and whether they're actually effective. So hold harmless agreements might be an effective way to protect against liability, but there's also a question of whether if you don't have a rule requiring somebody to sign a hold harmless agreement, either in an emergency rule or in a rule generally regarding use of the gym, I'm not sure you legally can require somebody that otherwise is allowed to use the gym, whether you can ban them from using the gym until they sign away their rights. I'm not sure a court would uphold that as reasonable unless there's a rule requiring it. So that, again, is something to talk to your legal counsel about. What we have advised our clients to consider doing at the appropriate time is to think about disclaimers and warning signs. You know, many, if not, it may be that every pool right now is required to post a warning sign saying use at your own risk, you know, no lifeguard on duty, use at your own risk. I think going forward, when amenities are reopened, unless we're forbidden from doing so by the health officer orders, I think posting a sign in any of the common areas or common amenities that are being reopened, stating that everyone uses at their own risk, it may not protect you fully from any liability or harm claims, but it certainly is something that could be protected, putting everybody on notice. You know, we can't do everything under the sun to keep you safe from what we don't know about or what we can't afford to do. So we think the better practice in many cases is to consider disclaimers and warning signs. The issues of insurance, you need to speak to the association's insurance agent or broker about when the amenities are reopened. Is the association protected against claims by users or third parties that somehow they contracted the virus, for example, or otherwise were harmed by the use of the common amenities? I know when the SARS condition came up, I think in about 2004, 2005, I'm told that and have seen that most HOA property and liability policies now have exclusions for conditions created by a virus or public health epidemic or pandemic as we're in right now. So one of the considerations the board needs to evaluate is whether you have insurance protection for specific types of risk that might otherwise cause you to consider whether you want to reopen the amenity at all, even if you're otherwise allowed to. And finally, most associations don't like spending money on legal fees, but given what's at stake here, I think every board needs to think long and hard about getting legal advice in making decisions that affect the health and well-being of everybody in the community and the liability of the association. And again, you should speak with the association's legal counsel about all of these decisions and the various considerations that we've talked about here and others that your legal counsel may think are relevant or may be unique to your communities. Rolf, any other considerations before we talk about examples?
Well, I think, well, just a couple things in terms of just some general housekeeping. We're at 1:42 right now, and it's supposed to be an hour with 30 minutes for questions. We're happy to be here, but Dave and Hannah, I'm going to look to you guys to time keep us, and if we need to, by necessity, start accelerating, because I think the lion's share of what we want to talk about is coming up, so I just want to make everyone aware of the time, where we're at with things. But again, these are all the things, there's a lot more involved to this than just opening it up. And again, what I would say about all of this is that, you know, doing your homework, checking with your professionals to make sure that you have all the bases covered if you're going to do this. But here's something else, I guess I'll throw it in here, is that so much of this is still pretty fluid in a lot of ways. I can tell you I'm on another board for a faith-based organization for my church, and houses of worship have certain limitations, and those limitations are supposed to be reevaluated in terms of mid-June, like June 21st or something like that. So it may be something, as we're talking about this, that, you know, it's being so fluid, you may want to wait until things lighten up a little bit or more information comes across. So I'm not sure if we're going to specifically address that, but at least wanted to put that information out there. So
yeah,
if you're thinking about how to process all this, that at least you have other options than just yes or no.
The fact that you can reopen an amenity doesn't mean you must. And you need to evaluate that. Let's talk about some examples. Let's go to the next slide. And Rolf, tell us about pools and spas.
So pool spas, number one. In fact, one of our clients over in the East Bay, folks clamoring, want to get back into that pool at Contra Costa County. And diligently, and the board has been phenomenal, diligently following up with Contra Costa Health. And without steering on the legal side of this, as of today, our reading of all of the Bay Area counties, except for one with certain conditions, is that pools are not yet included as part of even enhanced stage 2. That is not allowed, those are not allowed to be opened up until possibly stage 3. Now, there are some exceptions, and John's going to go into some of these details here in a moment in terms of how pools are defined, whether they're public or private, and some of those details. But as of today, officially, at least in the Bay Area, pools are public pools, as generally under the state of California homeowners associations are considered, are not qualified to open, except in one case that we're aware of, which is San Mateo County. And even in San Mateo, if you're going to open, you inherit essentially all of the enforcement actions under the health order for social distancing and actively monitoring the situation. So as of this writing, as of this speaking right now, they are still supposed to be closed. John, why don't you fill in the meat on the bone?
It's interesting. I'm not sure why there's ambiguity on this. The California, Title 22 of the California Code of Regulations, Section 65503, identifies public pools for purposes of environmental health regulation, which is what we're talking about here. Public pools includes all HOA pools unless they only serve 3 or fewer separate interests. And yet we hear anecdotally that many managers and board members have contacted the authorities and gotten conflicting information. An attorney, another ECHO board member, contacted the California Department of Public Health and got conflicting information on whether the governor's edict that all public pools are hereby closed applies to HOA pools. But state law defines HOA pools for the most part as public pools. I'm not sure why there's the confusion. The County of Los Angeles simply came out, the health department came out and said, these are private pools. Here's what you can do to reopen. The County of San Mateo and several other counties have certain reopening of pools. It looks like spas for the most part are closed. San Mateo says you can do it with active monitoring, which we interpret to mean having somebody on site and enforcing, which can be its own difficulty. But the association becomes responsible for enforcing all of the county health official directives regarding social distancing, use of high-touch surfaces, sanitation, masks, all of it that create huge liability risks for associations. This is a fluid situation. I suspect there will be another webinar in the near future addressing further orders and where are we now. But the rest of the Bay Area counties, pools are all closed per the county health official.
And there's no sign of that lifting anytime soon. So something we are actively monitoring, but as of today, that is the order. And again, as John said, per the state of California, pools are considered public under the laws of the state of California, certainly for environmental health, which this is directly related to. And spas would fall underneath that. So anything else you want to cover?
I know there are several counties that are still permitting it. Napa County, several in Southern California, some with restrictions. When pools are, when your county says you can reopen your pool, it is highly likely that there are going to be specific restrictions and requirements to do so. So how you go about doing it, you look to the county health official order. So Rolf, what about community rooms and clubhouses?
So community, and just really quick to touch on that in the chat line, I guess Santa Clara County, we're hearing could possibly reopen tomorrow if you fill out a form. Again, this stuff is so fluid. We just reviewed this morning, and that's new information that's just coming out. So as John said, check with the orders, but make sure you're not, if you do this, that you're following the guidelines to allow you to open it up. And really, clubhouse and community rooms is similar along those lines. As I mentioned, there's a limitation in terms of having appropriate social distancing, having high-touch surfaces cleaned and sanitized appropriately, wearing masks when you're not of the same household. All of those restrictions are still in place. For those that I'm out where I live is actually out in the valley in San Joaquin County. I was able to go out and have a meal with my family in a socially distanced atmosphere, which was great. Not doing that in the Bay Area counties as of yet, because that's part of enhanced stage 2. So clubhouse and community rooms will have those restrictions. But as we were preparing for this, there's another interesting wrinkle that John came up with in terms of the free speech legislation that was just passed a couple of years ago in the use of clubhouses that I think will exacerbate this. So John, you want to touch on that?
Well, this gets back to whether you should reopen your amenities, even if you're otherwise able to. So a couple years ago, new law went into effect, Civil Code Section 4515, that could be its own presentation, but generally, homeowners associations governing documents cannot prohibit the use of common area for assembly by residents and people they invite to discuss issues that are of public importance or public concern when the common area amenity is not otherwise in use. And in doing so, you cannot require people using for public interest reasons to pay a fee, obtain insurance. You can ask them to provide cleaning, but if they don't, it's still an association responsibility. You can ask them to provide security, but if they don't, the association still has to take that into account. And so what I would suggest with regard to clubhouses and community rooms, we are not only in an election year that's expected to be very contentious, we are also right now, as everyone knows, in the midst of a situation that is highly charged, very emotional, with protesting, and in some cases, some dangerous situations based on the offshoots of that. And given that anyone can use, for example, your clubhouse or community room, if it's available and not otherwise in use, without really having to follow any rules that you can enforce in advance, I would suggest that associations that have a clubhouse or community room, a meeting room, speak to legal counsel and think long and hard about whether this is the year that you simply keep that amenity closed down for everybody's protection. So there is going to be a challenge when we're able to meet in person again for board and member meetings. And if the clubhouse or community room is used for that purpose, I really don't think you can use it for that purpose, but tell everybody else they can't. I think you would need to consider closing it altogether and finding an alternative way to meet that we'll talk about for a couple minutes here soon. But I would think long and hard about whether you want to reopen at all, given the risks inherent that you really can't do anything about in advance.
And to clear up a point of confusion I saw on the chat line, I didn't mean by saying posting notices at the clubhouse that the clubhouses were opened officially as of yet. Every one of you in your annual disclosure, you should be putting out a place of somewhere in the community that you post notices officially that people can go to find official, agendas, board meetings, things of that nature. I was suggesting posting information up in that area, but didn't mean to imply that the clubhouses were in fact open at this time. So just wanted to clarify that. So let's jump down: sport courts, gyms, fitness centers. Not everybody is graced with these, but some of us are. Again, I think all the social distancing, that's especially high touch. When we were preparing for this, there's been a lot of discussion. I'm part of a group that represents the high-rise managers in San Francisco. And this was a discussion of quite a lot of length in terms of trying to figure out how to make this work. And I think the advice I would give here is, number one, it's not open yet based on everything that we're seeing under stage 2, especially under the non-enhanced. But once it is, and John, feel free to jump in, that you may want to talk about the at your own risk signs rather than taking on the protocols unless the county health order requires that you actively manage the rooms. John?
I agree. And this is one of the amenities that we've been asked about: hold harmless agreements. Well, you can adopt an emergency rule requiring a hold harmless agreement. The enforcement of that might be difficult, but I definitely think posting a sign in a gym when gyms are allowed to reopen based on the governor and the California Department of Public Health, posting a sign saying everyone use at your own risk and asking people to comply with the following steps regarding sanitation and compliance with the public health official orders would be sufficient to protect the association to the extent possible. And again, the orders allowing reopening will probably give you further directives in that regard.
And just so we're clear, those that have offices that are open, in fact, we're running skeleton crews in 2 of our offices. We're required to post our protocol in terms of cleaning, mask wearing, and so forth. We're actively required by the counties to do that. So as that happens, there will absolutely be guidance from the counties in terms of what you need to post up officially. So stay tuned for that. Parks, tot lots, hiking trails. This has provided, again, yet another opportunity to have discussion. You would think some of this would be fairly straightforward, but one of the things that's come up in San Francisco is people jogging on paths, if they're breathing heavily, and they may have, they may be breathing out droplets that could infect someone who's walking on the path. Therefore, in San Francisco, they do require that you have a mask with you in public, and that when you're within a 30-foot radius of somebody, that you don the mask just to prevent a possible spread. So there are rules of this. And as we talked about earlier, the counties are beginning to diverge. So what's happening in San Francisco is not what's happening necessarily in Contra Costa or certainly in San Mateo. So you want to be aware of that. I think for the most part, folks have opened up in terms of parks and hiking trails as long as you keep safe social distancing. But the tot lots in particular, things that would require regular active cleaning, you may want to still consider, what you do with those in terms of if you're required to actively monitor them, it may be more than the association is able or willing to take on.
And
John,
again,
anything to add to that?
surfaces, I would think long and hard about whether you want to, even if you can. So let's talk about meetings.
Yes, next slide, please. So we've become Zoom and GoToMeeting experts, haven't we? It's amazing how quickly we've been able to transition all of this. And we find that, interestingly enough, business can still continue without the traditional board meeting. And I've been doing this since August of 1988. So not as long as some of you, and maybe not as long as some of you have served on your boards, but been around for a little bit more than a minute. And that's been such a staple, and not just a social center, but a civic center for many of us. But we've discovered we can still conduct business through other means. And I think a lot of us are finding that in many respects, it's actually been fairly effective. And one of the things we teach when we teach on how to have effective board meetings is being able to make sure that when you have your open forum period, you allow people to speak, but then once the meeting begins, whether you have your open forum at the beginning or the end, that homeowners are allowed to attend as spectators, but not as participants. And the way I always equate this is when you go to the state capitol, you have the Senate floor and you have the gallery. Outside of the open forum period, then the board is the Senate floor. Those attending are the gallery, and they're allowed to watch, but they're not allowed to participate. Now, I know some of you have very strong feelings in terms of trying to encourage member participation, which I'm a huge fan of that. But you also want to be careful of not getting too far afield of having the association be governed by committee, because ultimately the fiduciary duty rests with the duly elected board members, not with the members individually. And this is one of the main areas that causes board meetings to go 2, 3 hours, 4 hours, and even longer. So this style of doing it is actually finding that it's fairly conducive to that. However, there's been a big waiver of something required under California Civil Code that we've waived under the pandemic, but will come back again once this lifts, and that is a requirement of physical location in order to have two-way communication. So John, you want to touch on that?
Sure. So generally speaking, the Civil Code says that meetings can be conducted entirely by telephone or video conference, so long as there is a physical location for members to attend and observe and interact and be heard as appropriate. There has to be a physical location where somebody on behalf of the association is present for members to attend. And given the pandemic and the restrictions requiring social distancing and the restrictions against large gatherings, we have largely deferred for the last few months to Zoom and conference call meetings, or video conference and conference call meetings. At some point, we're not going to be able to say, well, it's simply not possible to have a physical location. But you see at the bottom of the slide, the hybrid solution, online and in person. We are seeing anecdotally that many more people are attending meetings in large measure. Members are attending meetings remotely because they can do it from their living room or wherever they are. And I'm not sure that everybody is going to want to necessarily go back to physical in-person meetings. So the hybrid solution might be to have a physical location where somebody is in attendance setting up the Zoom meeting, where if anyone wants to physically attend, they can, but everyone can still attend remotely. And I think in large measure, remote attendance and remote meetings in this fashion is something that's here to stay and that most people have really taken to. The challenges with all that is, what do we do when there are edicts requiring social distancing? If we only have a room that can hold, say, 5 people, How do you enforce who gets to attend? Is it first come, first served? Do you have a lottery? Is it only open to people that otherwise can't attend by phone or video conference? Those are all things to discuss with legal counsel. And this doesn't just apply to board meetings. We're seeing it apply to annual meetings, inspectors of election who are observed by the members opening and tabulating ballots via video conference. I'm attending such a meeting tonight. It can apply to hearings. It can apply to committee meetings, internal dispute resolution meetings with a member. The video conference and conference call meetings are here to stay, but we are going to have to take into account physical location at some point when we're able, and you should talk to legal counsel about how to do that. One thing about video conference, Echo provides a free online virtual meeting platform through Zoom for meetings that is free for Echo members. And you can register online at the Echo website, echo-ca.org, if you wish to take advantage of this service, if you are an Echo member. But one of the final things with Zoom, it gives the association, the board, or through your manager, if you have a third-party manager, the ability to control who's allowed to speak. And the law supports, the members have the right to be heard, but they don't have the right to intrude. And so the Zoom tools give you a much easier way to enforce that I think is really helpful.
Absolutely. So I hate to be the bad guy, but we're at the top of the hour and we have one more slide to get to. So real quickly on this slide before you move it, Hannah, is once clubhouses are allowed to be open, socially distanced protocols, all those things you'll just have to be aware of. But really, I think the salient point is what John just talked about in terms of in terms of looking for a hybrid solution. And I'm certain we're going to have some follow-up discussions on what that looks like. So if we can go to the next slide, please, and let's talk this. So we have 27 questions already online. I have a list of 18 questions that Hannah's already sent to us. We're not going to get to all of these, but this particular one's going to answer several, hopefully, that are in the Q&A. And there's the idea of budgets. What's the effect on the budgets and additional and unforeseen costs? And the corollary to this is, well, if I'm not using the amenity, why do I have to pay for it? And do I have an obligation to still pay if I'm not allowed to use it? And I'll let John speak to the legal part of that in a moment. But on the practical side for the budget, this really works two ways. It's number one, the association is required to set their assessments commensurate with their obligation under the governing documents, which means you don't get to pick and choose what you maintain. You have to maintain whatever you're responsible to maintain under your governing documents and the amenities that you have. Just because an owner can't use it does not mean that A, it's not being maintained, and B, that, quite frankly, the lack of maintenance could actually impair the use of that amenity down the road. So there are concerns about, well, do I have to pay assessments? And I think the uptake is, at least my understanding of 32 years of doing this, is that because they're called assessments and not dues, they're actually mandatory, and you can't not pay, forgive the double negative, the assessments based on your ability to use or not use the amenities. Correct, John?
Assessments are based on a budget that was put into effect prior to the fiscal year based on what was known at the time. And as the association's financial needs change throughout the fiscal year, the use of the collected funds may change as well. And the fact that what you actually need is different from what the budget said doesn't change the association's ability to adjust to meet its actual needs. So should there be refunds? No. The funds need to be put to different purposes, but the effect of the budget is one of the considerations to take into account on whether you open an amenity that you're now allowed to open simply because the cost of operating it, maintaining order, keeping it sanitary, and enforcing whatever edicts exist may be too high, may be beyond the association's capability. If you do open and don't have sufficient funds, the board does have the option of levying an emergency assessment for an expense that couldn't have been foreseen at the time the budget was prepared. You can do that without a member vote, but it requires a board resolution with findings of fact as to why it's necessary and why the expense wasn't foreseeable when the budget was adopted. The other thing we have questions about has to do with assessment collections. Should we waive late fees and interest for everyone because of these times, high number of unemployed, and we want to be empathetic to everyone? The problem with that is everyone is all associations are supposed to have delinquency and collection policies where the association has governing documents related to late fees and interest for delinquent accounts if people don't pay their assessments in a timely way. You don't want to take steps out of empathy that will encourage others who can pay not to, because there's no longer a downside. So I wouldn't recommend a wholesale waiver of late fees and interest in advance. What I would suggest is anytime a member comes to you and says, I lost my job, I'm in this situation, I can provide you documentation, I need a payment plan that might take that into account and adjust or eliminate late fees and interest. I think you look at that, you use your empathy coordinated with your business judgment to consider every payment plan under each specific individual circumstance. Liens and foreclosures. Liens are put into play for the protection of the entire association so that the association can collect its money. There isn't currently, with regard to foreclosures, there's pending legislation that may prevent foreclosures at some point going forward, but I don't think any such legislation has been passed. And you want to keep in touch with your legal counsel with regard to those considerations.
So go back real quick, just a couple more things on that. So someone asked about payment plans. Yes, we always encourage payment plans. In fact, they should, hopefully, if they're proactive and, in the preparation of this, I actually took the counter direction to what John recommended, and in doing this preparation, I agree with John. We tended to fall more on the empathetic side, but there is an obligation to make sure that you're following up. But the hope is that if an owner knows that they can't pay because they've lost their job, that they're hopefully being proactive and reaching out to the association to set up that payment plan. Always recommend that you consider a payment plan. You're trying to get the assessment income into the association, but I would not recommend letting it go any more than 6 months in terms of a repayment plan, because they still have to keep their existing assessments current while they repay whatever is in arrears. So you want to balance that out. And again, that's not a civil code thing. Our general thing is between 3 and 6 months. And if there's a need to reevaluate that, as John said, it's always best to have them come and ask and make it official on a case-by-case basis. That way you're being consistent with how you handle it with all of your owners.
And one question is, with a payment plan, should you consider requiring a voluntary lien to secure the debt that otherwise can't be paid for a period of time? That's absolutely something that can be considered as part of a payment plan to work with an owner's individual situation while protecting the association. So there's a certain period of time that you have to wait to record a lien and a certain size of debt to record a lien that isn't voluntary. But there's nothing that says you can't ask a member requesting an extended payment plan that can't currently pay to agree to have a lien recorded. You want to speak to legal counsel and the association's collection agent in terms of how to execute that, but it's a very good consideration.
Okay, last slide. So what if shelter in place is reinstituted? Well, my first bullet point is I hope you all have been taking good notes. Because we may be running this playbook out yet again if things happen to recur. As you've already seen in the chat line, we will be preparing materials and the video for your use down the road to make sure that you are equipped with this information so you can revisit it. Again, we're covering a lot of ground during this time, but the important thing is, review the new or updated orders, see what they entail. They will probably be more specific to counties because, as we know, one size fits all is the approach up front, but that generally doesn't work. It does not work at all long term. So make sure it's specific to where you're located. Always check with legal counsel. Again, it's money well spent to make sure that you're not running afoul and taking on liability you don't intend to. And then ultimately making informed decisions. Consult with your experts. Follow the business judgment rule. Do what reasonably prudent people would do in similar circumstances under the advice of others that you trust and believe to be competent. And then ultimately communicate early and often with your members. Get in front of them. Don't let them craft the narrative. If something's coming down the pike, just do your best to get out in front. And even if you don't have all the answers, it's important to say that, look, we don't have all the answers. And in fact, in in many of the memos I've been sending out, I say, look, this is very fluid, and we're taking certain actions on what we know in real time. And if that changes, we'll let you know. But until it does, this is what we believe is the best course of action. So don't be afraid to be proactive along those ways, those lines, and do that, but to make sure you get that out in front of your membership. John, anything to add?
No, I think the questions that are coming in are going to address many more things. I apologize, we ran over with the length of the presentation. We did try and answer some of the questions that have come in as we've gone, but I think now we can, Hannah, if you want to, how do you want to handle the question and answer?
Yeah, I'll go ahead and start the Q&A, and I'll try to screen through the questions, and I'll ask them aloud, and you guys can go ahead and answer. And if you see one that maybe I miss and that I miss, feel free to read it aloud and answer it as well.
Real quick, oh, go ahead, John. You're going to do the same thing, I think. Go ahead.
Before Hannah begins, a couple of things. First, we've gotten a lot of questions about how do we reopen a pool and what do we have to do. Right. You know, what steps do we have to take? Those types of questions may largely be answered by the county health officer orders that allow you to reopen any specific amenity. So in terms of what steps you should take with cleaning, with the spacing or use of furniture, with do you need a monitor on site, I would start with looking at the county health officer mandates and orders, which may answer a lot of those questions, and I would expect to, particularly with pools. The other thing, oftentimes we get questions that have a very long explanation of a fact pattern unique to your community. In the context of this type of question and answer, there's really no way for us to try and go through a long fact pattern to condense it, to answer something that is relevant to everyone. So there are certain questions we may not be able to answer based on time constraints, but we would encourage you to reach out to ECHO if you have additional questions, and we have resources to be able to provide you some guidance.
Perfect. Yep. Go ahead, Hannah.
All right. So let me pull up these questions. We've got 32 of them in here, so we'll do our best.
Besides the 18 you sent to us.
What was that?
Besides the 18 that you already sent to us. That's 50.
Yes.
We'll get to, no, we won't get to all of them.
All right. Can they ask for renters' emails to communicate to them, since we have owners who do not pass on information?
I'll tackle that one, John. Again, you can always ask for emails, and this is always a debate that, you know, renters versus owners. And in the general context, historically, we've always, when we're talking about enforcement, we always look to the owners because they hold title. But in terms of communication to the residents, anyone who lives there is a resident. And oftentimes people who are tenants will end up buying into that association if they feel a good vibe and something opens up. So absolutely, in terms, as long as you're not sending official communications, John, if you want to touch on that, but in terms of any of this, I would certainly ask, and I would absolutely include them in any communications, because they are still participants in the community, even if they're not owners.
So if you're talking about issues that are for the general health and welfare of all of your on-site residents, I agree that it's a good thing to be able to reach all of the on-site residents. You can ask for the information. It's something you may want to talk to legal counsel about, whether a certain type of, whether an emergency rule related to the rental of units, whether the association has the authority to adopt such an emergency rule. That literally could be limited to, we need to have the direct contact information of residents during this pandemic to be able to communicate issues related to health and welfare. Being able to enforce that might be extremely difficult, but you can certainly ask for it.
Great. So next question. Is there any legal responsibility for an HOA to refund fees when amenities have been shut down for health reasons for a 2-month period?
No. The association is required to levy assessments to meet its actual and anticipated needs, both actual current and anticipated future, up to 30 years through the reserves. The fact that a budget was passed to meet the anticipated needs and the actual needs have been different from what was budgeted, doesn't mean that there is a requirement or even that it's a good idea to return whatever wasn't specifically spent on a specific amenity that was otherwise budgeted for, because the association's needs throughout the year are fluid and will remain fluid as the county issues additional orders. The same thing applies not only to what has been closed by the edict, the order of public officials in the past, but it applies to whether an association through the board decides not to reopen an amenity, exercising the board's prudent business judgment and fiduciary duty. There may be legitimate reasons related to expense and liability risk and health risk that would cause a board not to reopen amenities. That doesn't mean that the money collected in assessments based on a prior budget has to be given back. In any given situation, you should talk to the association's legal counsel, because you may want specific guidance on how to communicate with your members on this subject. It is much more of a political issue than a legal issue.
And as a practical matter, for instance, we've talked a lot about being in contact with your association's attorney. I can't tell you the number of budgets I've seen over the years that have legal budgeted at, I don't know, $500 a year or $1,200 a year. To get the counsel, that's an unanticipated expense. So I assure you there are expenses, as we try to communicate under that slide. You may be down in certain line items like utilities if you're not heating the pool, but you will be up in other areas like legal or signage that you had to get, things of that nature. So the hope is that it all comes out in the wash, but there are absolutely unanticipated expenses that are all part of your obligation in terms of the association.
Well, Rolf, let me ask you a question. So we're not here telling you that everyone should be happy about having to be in touch with lawyers consistently and pay more money on legal fees. So let's leave legal fees out of this and talk about the practical.
Right.
You have an association that when amenities are reopened and that have, or just the general common area, maybe you're doing it right now, that have high touch surfaces that will need to be cleaned in some fashion or should be cleaned in some fashion in ways that never were before, in the ways that might make sense now. How many of your associations, for example, have budgeted for someone to come in on a daily basis, 3 times a day, every other day, and wipe down every high-touch surface in the community? Is that something that typically is budgeted?
I believe if you're asking me for the count, I believe that count would be 0, because nobody anticipated this at the beginning of the year. And what does that look like as a practical matter? You know, there's been talk, I know in some of the high-rise groups, about do you put sanitary wipes at every opening? There's a cost to maintain that, let alone just the cleaning protocols. As we reopen our offices to the public, we're looking at enhanced cleaning for that, at least an initial cleaning, and then maintaining the cleaning after that. All of these are expenses that could not possibly have previously been contemplated and planned for. So even outside of the legal piece of this, there's plenty enough going on that you won't know until you get to the end of the year and you see how all of this really plays out. So in that respect, you trying to be in front of what you reasonably can is such a critical part of this.
But the keeping things sanitized or clean to the extent possible and the additional costs is a perfect example of where your money may be redirected that otherwise hasn't been spent up to this point, maintaining things in the normal way, allowing for normal use. But the association's actual needs will result in the reallocation of the resources that you have, which is why a refund is not legally required and typically would not be advisable.
So John, let me throw one at you. And I'm going to jump in here because this one's toward the bottom and this was probably going to be on a lot of folks' mind. So one of the questions, there's a concern that a member can challenge board decisions made over the last few months where meetings were done over video conference calls. Was there a state decision to formally exempt the physical location requirement? And do you believe, Counselor, that those decisions will actually hold up under scrutiny?
So we talked about this quite a bit, both within our own law firm and with other lawyers in the industry. And I want to say there was universal agreement we don't want to overgeneralize, but with the lawyers that I talked to, there was universal agreement that when the public health officials responsible for maintaining the public health talk about social distancing and no unnecessary gatherings, that the spirit of the law could largely be met with video conferencing, that every member has a right to utilize to participate in the meetings, to be heard during the appropriate time without there being a physical location to meet. So the letter of the law requires a physical location to meet, but the law also allows exceptions in any situation where there's an impossibility or an impracticality to meeting certain terms if the remainder can be met and are met in a good faith fashion. So there has not been an edict, there has been no legislation doing away with the physical location requirement. I've seen a question asking, is there legislation pending? I'm unaware of any legislation pending. I think it would be a great idea, and I think there's going to be a push for it based on everybody becoming familiar and comfortable with video conferencing. But I do know in my own experience, what I have heard quite a bit is that the governor has made it clear that he is only interested in legislation this year to the extent that it's absolutely necessary, and primarily dealing with the COVID-19 situation and emergency needs. So in that regard, I'm not sure this is the year that we're going to get legislation that would make us all happy from a practical standpoint regarding eliminating the physical location requirement. I can tell you though, I've defended associations in court regarding the conduct of meetings, the conduct of elections, all of it. I would be very comfortable explaining to a judge that the pandemic eliminated the practical ability to have a physical location for the meeting, but that everyone had the opportunity to participate by conference call or video conference. And I really can't imagine a judge saying that that's unreasonable. And if a judge does say that that's unreasonable, that's why we have the Court of Appeal. But I really don't think it gets there because it's so impractical in the greater context.
And again, not being an attorney, but the business judgment rule, what would reasonably prudent people do in similar circumstances? And right now there are obvious limitations. So,
and to that extent, your board would be well advised to get an opinion from legal counsel if you're concerned about this, that you as board members can rely on. So that if it is challenged and a court later were to say you shouldn't have done it that way, you as board members would be protected individually because you relied on the advice of legal counsel. And I think that would be an easy opinion to get.
Absolutely. Anything jumping out at you, Hannah? There's several I can take, but go ahead.
Yes, there's quite a few questions regarding a community garden. So if you guys want to just touch on that real quick and kind of where that falls.
Boy, that's unique to those that have them. To me, they would be akin to parks and tot lots and things of that nature. I know some counties are allowing some, hiking if you're local and not traveling, those things. But again, if there are areas within the community garden area where there are shared tools and things of that nature, I think you'd be well served to have a protocol of some kind, unless it's a bring your own tools, bring your own equipment kind of thing. But I think that gets down to, and some gardens are larger, some are smaller. Do you have appropriate social distancing? I think there'd be a troubleshooting kind of thing you'd want to go down to make sure that you're not falling afoul. With all of the conversation today, we're trying to equip you with the tools to evaluate risk. And there are some times where if the risk is low, it's okay to proceed. If the risk is high, you definitely want to proceed differently. So not in a position to tell you what to do, but to essentially hopefully put a framework that you can evaluate it based on your unique situation.
Okay. Next question. So if the county is allowing pools to be reopened, does the HOA, can they keep them closed legally?
I think this gets back to the board exercising its, complying with its fiduciary duty, exercising its prudent business judgment to evaluate whether it makes sense to reopen the pool under all of the circumstances, which would, for example, which would require complying with whatever the county health official requires in order to reopen the pool. Not only from a cost standpoint, because, for example, San Mateo County talks about active monitoring of pools in order to reopen, and active monitoring in the context of the association being required to enforce the county health requirements, health official requirements regarding social distancing, wearing of masks, and all the various other things that the county says have to be done, would become the association's burden to enforce. Well, active monitoring in that context, what that says to me is you have to have somebody present able to observe and ensure that everyone is complying with the county health official directives and restrictions. So not only do you have a cost burden with that, you have a liability burden with that. In that scenario, for example, I think the association should talk to its insurance broker about whether there is insurance protection for whomever is acting on the association's behalf as an agent, whether it's paid or unpaid, to enforce the county health directives on site in the active monitoring. You may have to pay somebody to do that. The association may be liable for any interactions that occur. There are all kinds of things that can happen, including what happens when somebody refuses to comply, is asked to leave and won't. At that point, you have the monitor on site that has decisions to make about how to intervene to get somebody to comply that won't, or get them to leave if they won't. These situations could get very uncomfortable. So there isn't a one size fits all in terms of whether you should reopen. I do think the board always has a fiduciary duty to evaluate what makes sense for everybody, which includes the consideration of all of those factors. And this is an example of where you ought to speak to legal counsel about how you do it if you choose to, and whether it's advisable.
Okay, next question. We've got a few minutes left, so we'll try to squeeze in a few more questions. How can you communicate when you have to sign a confidentiality form? Members often learn of upcoming decisions only by the agenda they pick up on the way into the meeting.
I'm not sure I understand the confidentiality form in that context, and agree that in many cases, members only learn what's going to be discussed at a board meeting from looking at the notice and agenda. It gets down to how your association communicates with members, and members' more active attendance at the meetings. But as a practical matter, there are only so many ways you have the ability to learn what's going on, and attendance at a meeting is the greatest one. I don't know what was meant with regard to a confidentiality provision.
Okay.
The only thing I could think of is possibly executive sessions, if that was something, because in executive session, those are specifically allowed to be held under California Civil Code under certain things, about 6 or 7 things that you can hold those for. So there is, legal personnel issues, negotiation of contracts with third parties, but even then, not aware of a confidentiality agreement per se that would preclude anybody from anything other than things that are discussed that are allowed under those items.
Okay, next question. So if vendors are providing full service, maintenance of any kind, and their contract is say twice a week, but they're now only able to do once a week, do you recommend negotiating a new fee?
John, I'll jump in on this one. I know you covered it last week with Bill. So here would be my take on that. During this season, everybody is affected on some level through the pandemic. The hope is that we're viewing our vendors as our partners in maintaining our associations. Oftentimes, the practical side of what's done, whether it's landscaping, janitorial, pools, and so forth, are done by those men and women that are out there for us all the time. It's a function of an evaluation, but I think it would be sending the wrong message to try to cut fees when they're probably trying to figure out what they're trying to do as well. Now, there might be some discussion that could be had along those lines, but I try to view our vendors as our partners, and to the degree that we're still able to take, to honor the contracts, that we should look to do that. John, anything you want to add to that?
No, you can always negotiate with your vendors, and you used the expression last week. You need to decide if your vendor is your business partner trying to help solve your problems, or is your adversary. But you can always discuss services available, services that you need, and the cost.
Yes.
Okay, just let's see what time we're at. 2:30. We'll do 2 more questions and then we will go ahead and wrap this up. And again, feel free to contact us with your questions after if you didn't get a chance to get it answered. Let's see. What about board of directors elections requiring a ballot counting to be observed for the turning in of ballots? How does this relate to online meetings?
I am attending an annual meeting tonight that is being conducted entirely by video conference. There are 3 inspectors of election. The inspectors of election have all discussed how they want to go about interacting while maintaining social distancing. The meeting is being conducted by a Zoom video conference that will, with the cameras positioned to be able to show all members that log in what the inspectors are doing, and the law requires that members be entitled to attend and observe the tabulation of ballots. So observe doesn't mean looking over somebody's shoulder. We have always recommended in election rules that there be restrictions on, for example, how close attending members in person can be to the inspector and non-interference. I think under the current circumstances, you can certainly allow members to observe the tabulation of ballots via video conference if the cameras are well positioned. And in my experience, that is becoming the norm in the current crisis.
All right, so last question. What advice do you have for handling irate messages, not threatening, and or violent remarks, emails, calls from members who don't agree with closed common areas?
That's a whole nother webinar.
Okay. I wasn't sure if that was a long-winded answer.
Well, I can tell you what we've been talking about internally with our staff is that, when people call us anyways, they're not calling us to get stock tips or to see how we're doing. They're already calling us under a pejorative situation where something has gone wrong and there's this expectation to fix it. And then there's this implied sense of urgency. So that's already there no matter what. When you're doing the kind of work that we do, whether board members or managers, that urgency is absolutely felt. It's absolutely real. And it's one of the things we take on as part of the duty. So the challenge always is to keep our head, our heart, and our wits about us while we're processing this. And of course, COVID-19 has exacerbated it for those who might be fearful and from those who think it's a restriction of liberty. And, again, it's not a partisan statement on my behalf whatsoever. What I try to do is look at the actual outcomes and say, okay, what can we do to try to approach this? So for us, what I try to teach my staff is that, when people are calling you, it's not really about you, even if you're the recipient of it in that moment. But to breathe, understand that, you don't know where they're at or what they're going through in that moment doesn't make it right. And there are days we have good days and bad days. There are days I'm on my pretty good behavior, and there are days where, it just feels kind of like a mouse trap. There were days during this pandemic that I felt like a clock spring just wound up so tight, and just one more click would just snap it. So we're all going through versions of that. So it doesn't excuse it, but to try to come at it from a place of humility, a place of listening. And most folks just want to be heard. So to the degree that you can listen to what people are saying, but then secondly, to follow up and follow through in a way where you may not be able to give them the answer that they need, but as long as you're getting back to them and not leaving a vacuum there, I think those are some practical things you can do to try to mitigate it. But, I think just you can turn on the news or go on to social media, and there's a lot of this out there, and, we're already subject to it. So it's definitely a challenge, something we all have to fight, to be intentional, to try to comport ourselves from a right place and a right heart.
Thank you.
Weigh in on that a little bit too. The question both said non-threatening and violent. So Non-threatening, everyone has a right to be angry. Everyone has a right to an opinion. The board has a duty. And there's a difference between your duty and your members' opinions. You may share their opinions, but still have to make decisions consistent with your duty. If somebody leaves violent messages, I would save them and contact the police. If people express how unhappy they are, that is normal, sometimes unfortunately normal, but it's normal. And one of the ways to deal with that, if the board makes a prudent business decision not to reopen an amenity, I think that is an opportunity to write a letter to the members explaining why the decision is being made and going through all of the considerations that the board evaluated, including a discussion with legal counsel about what should and shouldn't be done under the best circumstances. So you can explain to people why the amenity isn't being opened and under what circumstances it might, if you know. But it's not just that you want to communicate with somebody that's already hopping mad and wants to talk about it. You want to communicate with everyone about what you're doing and why when we're in an unusual situation, and you may be able to blunt much of the anger. Or even if people are still angry, at least it won't be out of misunderstanding. And if everyone wants to recall the board and come in and make decisions themselves, that's their right. And frankly, if I'm on the board, I can't take that personally, but I have to do the right thing as I see it.
All right, thank you guys. Thank you again to our speakers, John and Rolf. You guys, thank you for your time and expertise. You guys did a fantastic job. And there's many questions, of course, that we didn't get to. Just with time constraints, feel free to reach out to ECHO and we'll do our best to get those, get some answers for you. And thank you again to our sponsors, our program sponsor, OMNI Community Management, and our Q&A sponsor, Hughes, Gill, Cochrane, Tinetti. And just want to let you guys all know we do have another statewide webinar coming up on June 26th that's on challenges and possible solutions for small HOAs. So everyone that's in a small HOA, this is definitely going to be geared toward you guys, and we hope to see you at that one as well. And that registration will be available soon. And at this time, I don't have anything else. And I just thank you guys all for attending and supporting ECHO. And thank you again to our speakers, John and Rolf.
Thank you guys for being here. We appreciate it.
Thank you so much. Appreciate it. Take care, everybody.
All right. Bye, guys.
Bye now.